What are the exceptions to the rule that certiorari is not a substitute to a lapse remedy of appeal? When public policy and the advancement of the public welfare so dictate. Number two, when the broader interests of justice so require. Three, when the writs issued are null. Four, when the questioned order amounts to an oppressive exercise of judicial authority. Late 4, Electric Cooperative versus LIECO, IV employers, or for employers. 5, when appeal is not a plain, speedy, and adequate remedy. P files a collection case for $500,000 against D. D was declared in default on the ground that his answer was filed beyond the reglementary period. D filed a motion for reconsideration in which he submitted proof that his answer was filed on the 15th day from service of summons. The trial court denied the motion on the ground that it was not accompanied by an affidavit of merit. Default judgment rendered against D, who received a copy of the judgment on March 1st. D filed a motion for reconsideration which was denied in an order received by D on April 1st. On May 3rd, D filed a special civil action for certiorari with the CA to set aside the default judgment. P argued that the petition should be dismissed since the proper remedy was appeal. Should the petition for certiorari be dismissed? The answer is no. The trial court acted with grave abuse of discretion when it declared the defendant in default, despite the fact that there was proof that he timely filed his answer. Furthermore, a motion for reconsideration did not be accompanied by an affidavit of merits. Appeal is not an adequate remedy since D was not able to present any evidence before the court à and the appeal would hence be decided on the basis solely of the plaintiff's evidence. Balangkat versus Court of Appeals, GR 83888. P filed a collection case against D before the RTC. P won the case and D filed a notice of appeal. P then filed with the RTC a motion for execution pending appeal on the ground that he was posting a bond to indemnify D for any damages that may be caused him by the execution and on the ground that D's appeal was flimsy and dilatory. After due notice and hearing, the RTC granted the motion. Letter A. Was the grant of the motion for execution pending appeal proper? B. What would be the remedy of D against the execution? Answer to letter A. The mere posting of a bond is not a good ground for the issuance of discretionary execution. Otherwise, execution pending appeal would issue as a matter of course. Likewise, the ground that the appeal is dilatory is not a good ground. Otherwise, the trial court would be virtually preempting the appellate court's decision on the appeal. Ong versus Court of Appeals. 203 SCRA 38. Answer to letter B. D may file a special civil action for certiorari to set aside the order granting execution pending appeal. The order was issued with grave abuse of discretion amounting to lack or excess of jurisdiction. Appeal, although available to D, is not an adequate remedy, as the writ of execution was already issued. Presbitero versus Rodas. C filed a complaint for illegal dismissal against X company before the labor arbiter. The labor arbiter ruled in favor of C and ordered his reinstatement and the payment of back wages. X company appealed to the National Labor Relations Commission, which set aside the labor arbiter's decision and found that the dismissal of C was valid. C's motion for reconsideration was denied. What is the remedy of C from the NLRC's adverse ruling? C's remedy is to file a special civil action for certiorari with the Court of Appeals on the ground that the decision of the NLRC was rendered with grave abuse of discretion amounting to lack or excess of jurisdiction. The petition for certiorari should be initially filed with the Court of Appeals in strict observance of the doctrine of the hierarchy of courts. St. Martin Funeral Home versus NLRC 295 SCRA. JEWM Corporation bought 2 parcels of registered land covered by TCT numbers 235675 and 2325 677. on which notices of list pendants, including that of a case filed by the spouses Crisogolo against JEWM's predecessors in interest, were annotated. JWM filed with the original trial court an action against the Register of Deeds and John and Jane Doe's to cancel the notices of list pendants on the registered land pursuant to Section 108 of the Property Regulation Decree. The spouses Crisologo were not impleaded. The spouses Crisologo filed a motion to be recognized as parties, but did not file a motion for intervention on their belief that they were included among the John and Jane Doe's. The RTC denied the motion in a subsequent motion for reconsideration. The spouses Crisologo thus filed a petition under Rule 65 with the Court of Appeals to set aside the RTC's order. The CA dismissed the petition on the grounds that there were adequate reliefs available to the spouses Crisologo, that is, a motion for intervention and appeal, and that the spouses Crisologos are non-parties in the RTC case cannot avail of Rule 65. Did the CA act correctly in dismissing the petition for certiorari? The answer is no. The spouses Crisologos liens were annotated at the back of TCT numbers 325675 and 325676. Thus, as persons with their liens annotated, they stand to be benefited or injured by any order relative to the cancellation of annotations in the pertinent TCTs. In other words, they are as indispensable as JEWM itself in the final disposition of the case for cancellation, being one of the many liens holders. As indispensable parties, the spouses Crisologo should have been joined as defendants in the case pursuant to Section 7, Rule 3. Although intervention under Rule 19 could have been availed of, the failure to use this remedy should not prejudice spouses Crisologo. It is the duty of RTC BR 14, following the rule on joinder of indispensable parties, to simply recognize them with or without any motion to intervene. Through a cursory reading of the titles, the court would have noticed the adverse rights of spouses Crisologo over the cancellation of any annotations in the subject TCTs. Neither will appeal prove adequate as a remedy, since only the original parties to an action can appeal. Here, spouses Crisologo were never impleaded, hence they could not have utilized appeal as they never possessed the required legal standing in the first place. Moreover, appeal is not available as against an interlocutory order. The same is also true if recourse to annulment of judgment under Rule 47 is made, since this remedy presupposes a final judgment already rendered by trial court. The fact that the spouses Crisologo were not parties in the RTC should not preclude resort to Rule 65 because they were indispensable parties, and the lack of legal standing was not their fault. The Supreme Court thus struck down the CA rulings and ordered the remand of the case to the RTC for the spouses Crisologo and all other lien holders to be impleaded. Crisologo versus JEWM Agro Industrial Corporation, 2014, March 3. Seguin Reyna, Montecillo, and Ongsiaco Law Offices, or SRMO, acted as counsel for Remedios and Rodriguez, when she commenced an action for the intestate settlement of the estate of her deceased husband, Susano Rodriguez, before the RTC. During the pendency of the intestate proceedings, Remedios asked for the payment of widow's allowance. She was subsequently granted a monthly widow's allowance of $3,000. While the case was pending, Remedios executed a deed of sale of inheritance wherein she agreed to sell all her rights, interest, and participation in the estate of Gerardo in consideration of $200,000. Remedios executed a special power of attorney authorizing Gerardo to receive all monies due to her from the inheritance or estate. Gerardo later on executed a document titled a substitution of attorney in fact, where he designated SRMO as substitute attorney pursuant to the power of substitution granted to him in the earlier special power of attorney. Geraldo subsequently executed his own SPA authorizing SRMO to appear and represent Gerardo in any and all proceedings and incidents in the state proceedings. SRMO filed a motion with the RTC for the payment of the allowance, then amounting to a total of 315. A few months after, the state remitted to SRMO 303 checks totaling this amount. Subsequently, the RTC motu proprio directed SRMO to reimburse the state the amount of 315, representing the widow's allowance it received. The court stated that Remedios was no longer entitled to the allowance after selling her hereditary share. SRMO moved to be excused from reimbursing the estate. According to SRMO, when it sought the payment of the widow's allowance, it was merely seeking the enforcement of a judgment credit in favor of its client Remedios, who had in turn sold her interest to Gerardo, also represented by SRMO. The RTC denied SRMO's motion. Agreed by the RTC's order, SRMO elevated the case to the CA to a petition for certiorari. SRMO argued that it merely acted as representative of Gerardo, Remedios' successor in interest, when it received the sum corresponding to the widow's allowance without going into the merits of the case. However, the CA denied SRMO's petition on the ground that the latter was not a party in the case before the lower court and therefore had no standing to question the assailed order. Was the denial of the petition on such ground correct? The answer is no. The general rule is that a person not a party to the proceedings in the trial court cannot maintain an action for certiorari in the CA or the Supreme Court to have the order or decision of the trial court reviewed. The peculiar facts of this case, however, call for a less stringent application of the rule. The facts show that SRMO became involved in its own capacity only when the RTC ordered it to return the money that it received on behalf of its client. The order of reimbursement was directed to SRMO in its personal capacity, not in its capacity as a counsel for either Remedios or Gerardo. The SRMO is being required to reimburse from its own coffers money already transmitted to its client is sufficient to give SRMO direct interest to challenge the RTC's order. Sigwin Reyna Montesilo, Ongsiaco. A complaint affidavit was filed with the Office of the Ombudsman against Mayor Jejomar Binay, Jr., charging him with plunder and violation of the anti-graft law in connection with the construction of the Makati City Hall parking building. The OMB issued an order placing Binay under preventive suspension without pay for not more than 6 months during the pendency of the investigation. Binay filed a petition for certiorari with the Court of Appeals, seeking the nullification of the preventive suspension order and praying for the issuance of a TRO and or writ of preliminary injunction to enjoin its implementation. The OMB filed a motion to dismiss the petition invoking Section 14 of RA 6770 of the Ombudsman Act, which reads as follows. Section 14, Restriction. No writ of injunction shall be issued by any court to delay an investigation being conducted by the Ombudsman under this Act unless there is a prima facie evidence that the subject matter of the investigation is outside the jurisdiction of the Office of the Ombudsman. No court shall hear any appeal or application for remedy against a decision or findings of the Ombudsman except the Supreme Court on pure question of law. Should the motion to dismiss be granted? The answer is no. The first paragraph is irrelevant since it evidently speaks of a writ of injunction issued as a provisional remedy. This is shown by the phrase to delay an investigation being conducted by the Ombudsman. Hence, the first paragraph does not deal with subject matter jurisdiction. The second paragraph, on the other hand, is unconstitutional and void. It limits the remedy against decision or findings of the Ombudsman to a Rule 45 appeal and thus attempts to to effectively increase the Supreme Court's appellate jurisdiction without its advice and concurrence in violation of Section 30, Article 6 of the Constitution. Since the preventive suspension order is interlocutory and thus unappealable, the remedy for an aggrieved party is Rule 65 petition with the CA pursuant to the doctrine of hierarchy of courts. Carpio Morales v. Court of Appeals. Is the filing of a motion for reconsideration of the court's or quasi-judicial body decision, order, or ruling a requirement for the filing of a special civil action for certiorari? The answer is yes. The general rule is that the person filing a special civil action for certiorari should first have moved for the reconsideration of the court or quasi-judicial body's decision. The reason is to afford the court or body an opportunity at the first instance to correct the imputed error. BA Finance Corporation versus Pineda. Is the foregoing rule subject to exceptions? Yes. In the following instance, a prior motion for reconsideration is not necessary when the challenge order is a patent nullity. Lucent Surety versus Marbella, L1688. When the case involves matters of extreme urgency, Matutina versus Bulson, L14637. When the issue raised is one purely of law, Amante versus Season, 60 Phil 949. Where public interest is involved, National Electrification Administration versus Court of Appeals. When the question raised in the certiorari petition had been properly raised, argued, and submitted to the respondent court or body and passed upon by it. Fernandez versus Kaluwag, L1612-4. A judgment was rendered by the RTC granting the petition for declaration of presumptive death of the spouse filed by the private respondent. Without filing a motion for reconsideration, the petitioner republic filed a petition for certiorari under Rule 65 to set aside the RTC's decision. Petitioner's main contention is that private respondent filed to establish a well-founded belief that his missing wife was already dead. The CA dismissed the petition because no motion for reconsideration was filed with the court à quo. The Supreme Court ruled that such defect was fatal and warranted the immediate dismissal of the petition. Was the dismissal of the petition on this ground proper? No. Parties cannot seek reconsideration nor appeal decisions in summary judicial proceedings under the Family Code because by express mandate of Article 27 or 247 of the Family Code, judgments rendered thereunder are immediately final and executory. While parties are precluded from filing a motion for reconsideration or a notice of appeal, in a petition for declaration of presumptive death, they may challenge the decision of the court à quo through a petition for certiorari to question grave abuse of discretion amounting to lack of jurisdiction. Republic versus Kaluwag. In a petition for financial rehabilitation filed with the Special Commercial Court pursuant to the Financial Rehabilitation and Insolvency Act of 2010, what is the remedy of an aggrieved party from an order approving or disapproving a rehabilitation plan? The remedy of the aggrieved party is to file a petition for certiorari with the Court of Appeals under Rule 65 within 15 days from notice of the decision or order. Section 2, Rule 6, 2013 Financial Rehabilitation Rules of Procedure. Where should a special civil action for certiorari seeking to set aside an interlocutory order of the RTC in a local tax case be filed? With the Court of Appeals or the Court of Tax Appeals? The Court of Tax Appeals. The power of the CTA includes that of determining whether or not there has been grave abuse of discretion amounting to lack or excess of jurisdiction on the part of the RTC in issuing an interlocutory order in cases falling within the exclusive appellate jurisdiction of the tax court. It thus follows that the CTA, by constitutional mandate, is vested with jurisdiction to issue writs of certiorari in these cases. Since appellate jurisdiction over private respondents' complaint for tax refund is vested in the CTA, it follows that a petition for certiorari seeking nullification of an interlocutory order issued in the said case should likewise be filed with the same court. To rule otherwise would lead to an absurd situation where one court decides an appeal in the main case while another court rules on an incident in the very same case. City of Manila versus Grecia Cuerdo, 715-162. Petition for prohibition. What is the special civil action for prohibition? An extraordinary remedy by which an aggrieved person's prays for a judgment commanding a tribunal, corporation, board, officer, or person, whether exercising judicial, quasi-judicial, or ministerial functions, to desist from further proceedings in an action or matter on the ground that such proceedings are without or in excess of its or his jurisdiction, or with grave abuse of discretion amounting to or lack of jurisdiction. Give examples where prohibition may be availed of. Prohibition is proper to restrain a sheriff from executing a judgment which was not yet executory. Blossom versus Manila Gas Corporation, 47 Phil. Or from levying on properties of the judgment, obligor, which are exempt from execution. Antonio, a resident of Pampanga, filed suit in the Regional Trial Court of Manila on a promissory note executed by Andres, a resident of Cavite. The latter moved to dismiss on the ground that the venue is improperly laid. The motion was denied and Andres wants to question the denial before a higher tribunal. If you were Andres' lawyer, should your petition be for certiorari, for prohibition, or for mandamus? If I were Andres' lawyer, my petition would be for prohibition. The Supreme Court in Enriquez versus Macadaeg has held that the remedy where a motion to dismiss is improperly denied is prohibition. Here, the motion to dismiss was improperly denied under Rule 4, venue of personal actions is the place where the plaintiff or the defendant resides. At the plaintiff's election, but here the case was filed in Manila where neither the plaintiff nor the defendant resides. Hence, a petition for prohibition would be proper. Note, it is submitted that certiorari may also be availed of in order to set aside the order denying the motion to dismiss. Petitioners, members of an urban poor organization, filed a petition for prohibition and mandamus with the Supreme Court to stop respondents' DILG, secretary, and mayors from evicting them pursuant to the Urban Development Housing Act, or RA 7279, and to compel the respondents to afford them judicial process prior to evictions and demolitions. Section 28 A and B of RA 7279 provides that eviction and demolitions may be allowed without any court order when one person, number one, or entities occupy danger areas such as estates, railroad tracks, garbage dumps, riverbanks, shorelines, waterways, and other public places such as sidewalks, roads, parks, and playgrounds. And two, persons or entities occupy areas where government infrastructure projects with available funding are about to be implemented. Did the petitioners properly avail of prohibition? Answer is no. Prohibition is available against a respondent exercising judicial, quasi-judicial, or ministerial functions. In exercising the power to demolish and evict illegal structures pursuant to RA 7279, the respondents are clearly not exercising judicial or quasi-judicial powers. Both judicial and quasi-judicial functions involve the determination of what the law is and what the legal rights of the contending parties are with respect to the matter in controversy, and, on the basis thereof, the facts obtaining the adjudication of the respective rights. Nor is there a ministerial duty on the part of respondents. Section 28 of RA 7279, in authorizing evictions and demolitions, uses the word may. Clearly, there is discretion on the part of respondents to implement demolitions and evictions, and thus there is no ministerial duty. Kalipunan ng damayang mahihirap versus Robredo. Why is prohibition an extraordinary remedy? Because it is only available where there is no appeal or any plain, speedy, and adequate remedy in the ordinary cause of action. Distinguish certiorari from prohibition. The purpose of certiorari is to annul proceedings had without jurisdiction or in excess of jurisdiction or with grave abuse of discretion. Hence, certiorari is a corrective remedy and operates on acts already consummated. On the other hand, prohibition is a preventive remedy whose function is to restrain the doing of some act about to be done. It is not intended to provide a remedy for acts already accomplished. Agustin versus De La Fuente, 84 Phil. Certiorari is directed only against judicial or quasi-judicial acts, while prohibition may be directed against judicial, quasi-judicial, or ministerial acts. Distinguish injunction from prohibition. Injunction is generally directed against a person not exercising judicial, quasi-judicial, or ministerial functions, while prohibition is directed against a tribunal, corporation, board, officer, or person exercising judicial, quasi-judicial, or ministerial functions. Injunction may be the main action itself, or just a provisional remedy in the main action, whereas prohibition is always a main action. Where an action for prohibition is filed, the petitioner may seek the provisional remedy of preliminary injunction against the respondent. Distinguish prohibition from mandamus. The object of mandamus is to compel a tribunal, corporation, board, officer, or person to comply with a ministerial duty, while prohibition has for its object that of preventing the tribunal, corporation, board officer, or person from executing an act not within or in excess of its jurisdiction. Mandamus is an affirmative remedy for its commands that something be done. Prohibition is purely negative, for it commands that something be left undone.